All good. Thanks, Kevin.
Thanks. So from the outset, I'm joining you today from Dharawal land, that's in the Illawarra. However, I'd also like to acknowledge the traditional custodians of the land from where I work in Canberra, the Ngunnawal, the Ngambri peoples. And I offer my respects to their elders past, present and emerging, and any other Aboriginal and Torres Strait Islander people joining us online today, including Yenda and Liana. So in June last year, in the ACT, a 13-year-old was charged with a shooting murder by Joint Commission, which was alleged to have occurred as part of an attempted burglary. This occurred when he was 12. And so this charge was, you can see that on the right there. This charge was discontinued when he was in late June, but his testimony was recently central to the conviction of an 18-year-old man. So already this 13-year-old has been deeply involved in the ACT's criminal justice system. Similarly, in Victoria, in October last year, another 13-year-old was committed to trial for stabbing murder, also by Joint Commission, of a 16-year-old in March last year. And just about a week or 2 weeks ago, the 13-year-old was denied bail due to the near inevitability that he will offend again. If we move on to the next slide, on an average night in Australia across the country in June 2022, 44 children aged 10 to 13 years were in detention. Of those 44, 98% were unsentenced. They were there on remand. And 76% of those were Aboriginal and Torres Strait Islander. In the ACT, our numbers look a bit different given our size. However, over the past 4 years, children aged 10 to 13 have been detained on about 65 occasions, which is still relatively significant. Recalling that previous slide, those media responses often they spotlight younger children in the criminal justice system when they're charged, when they're tried, when they're sentenced. And yet what these reports often overlook is how did these children, young people get there in the first place, and what sort of service system could have better supported them. So as Mark said, the ACT is the first jurisdiction in Australia to commit to raising the age of criminal responsibility to 14 years of age. And it's released a position paper in November last year about how to achieve this truly significant legal change. It is quite complex. This process has been informed by community consultation and an expert review of the ACT services system, and legislation is expected early this year. So in speaking to you today, my brief is to unpack the human rights issues around this and the role of lawyers in the ACT's process. In terms of a structure, I'll sort of go over, it'll sound very familiar based on what you've just heard, but I'll go over what the human rights impetus for raising the age is, but also some of the human rights issues to be aware of in how the overall reform is designed and implemented. I'll be focusing on two issues, and those are how do you meaningfully address harmful behaviours by children who are younger than the new age of criminal responsibility, and what sort of exceptions, if any, are consistent with human rights. So before we do that, if we move to the next slide, I need to take a detour through what I mean when I'm referring to a human rights framework, and second, and then later down the track at the end of the presentation, why it's so important to law reform in the ACT. Mark's told you that there's 3 human rights jurisdictions in Australia. There's Queensland, there's Victoria, and the ACT as the first. What this means is that we have legislation like that Human Rights Act there on the slide that applies certain human rights locally and allows them to be interpreted with reference to international law and judgments of foreign courts and tribunals. The Human Rights Act recognises a range of rights, including those that are absolute and can never be limited, so things like torture, the prohibition on slavery. But it also recognises what's called qualified rights. And these are rights that can be subject to reasonable limits set by laws that can be demonstrably justified in a free and democratic society. These include rights like privacy, movement, expression, liberty. Now, this is probably the key thing to know about a human rights framework, is that for a measure to limit a human right in a way that's permissible, it has to meet 4 criteria. It has to be authorized by law. It has to address a legitimate public purpose. It has to have a rational connection, which is to say it must be, at least in theory, a rational way of achieving the purpose that it's set out to achieve. And then what distinguishes it from the just a normal public policy process is it has to be the most proportionate impact on a human right in the circumstance. It has to be most proportionate action available to achieve that purpose. So this assessment is the crux of a human rights framework, and if anything, it's what I hope to leave you with. Human rights provide a lens over government action and lawmaking to ensure that any measure that impacts on the life of a human being is lawful, rational, and has the least excessive impact possible in the circumstances. So sort of getting into why we're raising the age from a human rights perspective, human rights directly underpin this push both in the ACT and across Australia. As you've heard, for the moment, in all states and territories, the youngest age the child can be convicted of an offence is 10 years of age. The Northern Territory's legislation will commence soon, but it hasn't yet. Children younger than that are said to be incapable of forming criminal intent. Now, if you're thinking, wow, that's a lot younger than I thought, and I know you're not because you've already heard that it's 10, but if you didn't know that before today, you're not alone, because according to polling done by Amnesty International in Australia, only 7% of Australians realise that a child can be charged with and convicted of an offence anywhere in Australia from the age of 10. Over half of those who were surveyed by Amnesty actually believed the national age was 14 or higher. And that's an understandable error too, because we're out of step with international practice. The median age internationally is 14. And as a result, Australia has been consistently criticised by a range of UN treaty bodies responsible for the elimination of racial discrimination, for instance, civil and political rights, and most recently in October last year, a committee responsible for the prohibition of torture and ill treatment. And that sort of responds to what Asham was talking about earlier with respect to Dondale and cultural impacts on Aboriginal and Torres Strait Islander people. So why then, from a human rights perspective, is this age of 10 considered unacceptably low? And it basically boils down to this. Limits on human rights need to be rationally capable of achieving their stated public policy purpose and proportionate to achieving that objective. And this has to be a holistic assessment. It's one that takes account of the overall impact of the legal rule in its context, or the change in the legal rule. Where we get human rights takes account of evidence. So it reflects that over the consideration of the right to the minimum age of criminal responsibility and why it's so low reflects the growing evidence and expert consensus on cognitive neuroscience and brain development of children, which has called into question their ability to conclusively, or their conclusive ability to form a criminal intent to a requisite legal standard. That is, it's not certain that a child can form mens rea to the standard that we would require for a criminal conviction. Under international human rights law, the rights of children entitle them to special protection due to their age, their physical and psychological differences, and the vulnerability that can come with depending on adults for their survival and development. These differences provide a basis for recognising lesser culpability and having a separate system with a differentiated, individualised approach. So in this spirit, the Convention on the Rights of the Child that Asham mentioned earlier obliges countries to set a minimum age below which children shall be presumed not to have capacity to infringe the penal law. And Australia is a signatory to the Convention on the Rights of the Child. Now, under the UN system, there are expert human rights bodies. There are committees that publish authoritative statements about how particular human rights should be interpreted in various contexts like, for instance, children's rights in youth justice. Now, until recently, the United Nations Committee on the Rights of the Child indicated that 12 years of age was the lowest minimum age that would be internationally acceptable. That was a position established in 2007. However, as of September 2019, just pre-pandemic, a new general comment was issued revising this position, and it took into account a decade's worth of recent findings about juvenile brain development during adolescence. Those findings said that for children aged 12 to 13, their frontal cortex is still developing, and with it, that includes their capacity for abstract reasoning. Rapid brain development during adolescence affects risk-taking, certain kinds of decision-making, and impulse control. So we can't assume, therefore, that a child's capacity to distinguish right and wrong and anticipate the impact of their actions in a personal context, as opposed to generally speaking, is the same as adults. In addition, a child's ability to form criminal intent might be further limited where they have multiple and complex needs, and these could include developmental delay, neurodivergence, disabilities, mental illness, substance abuse, family violence, and trauma histories. And this is important for us in Australia because our youth detention population very often has complex needs, trauma history, or are from marginalised communities. And so this brings into play the right to equality and non-discrimination. Raising the age is a way of sort of redressing a systemic imbalance, or at least attempting to. Similarly, another thing to, sorry, Mark, I've been terrible.
I'm keeping up. It's okay.
No, good. So similarly, another thing that affects a child's ability to make good decisions in the moment and to sort of regulate their emotions, impulsivity or risk-taking, is the influence and pressure of their peers, other children. And what you might recall from those first two examples, the 13-year-old in Victoria and the 12-year-old in the ACT, is that both of their alleged offending occurred in company. It was a joint commission. And this is a very common feature of youth offending. So having acknowledged all these sort of findings, the Committee on the Rights of the Child ultimately concluded that 14 is now the lowest minimum age that should be internationally acceptable. They urged state parties to increase their minimum age to at least 14 years of age. So as you would imagine, this new general comment, number 24, provided a significant catalyst for advocates like organisations like Change the Record, Amnesty and the Human Rights Law Centre and the lawyers that work within them to re-enliven campaigns to raise the age to at least 14 years of age, with particular emphasis on the human rights of children. And there have been a couple of key personalities who have been very effective in that space. One woman worthy of mention is Sophie Trevitt, who's worked tirelessly on this campaign. But then beyond that, there's also a question for a human rights purpose about whether youth justice for younger children is, at least theoretically likely to achieve its aim. Evidence has called into question whether youth justice responses are even actually effective. Because one of the most generally accepted tenets of criminology is that most children grow out of their offending behaviours. Where Australian children do offend, and barring other factors, their rates of offending usually peak in adolescence and then they decline into early adulthood. And this is evidenced by the Victorian Sentencing Council, which did a research project on its youth justice population. And what it found was that the earlier a young child comes in contact with the justice system, the likelier they are to continue reoffending. Children aged 10 to 12 years at the time of their first sentence were 86% more likely to reoffend, and 13-year-olds were 84% more likely to reoffend. And then, of course, as Asham's so eloquently described, the lifelong impacts on the child are also really dire. Children in contact with the criminal legal system are likely to suffer worse health and educational outcomes, employment outcomes too down the track, and according to the Australian Medical Association, it significantly increases their risk of dying at a younger age than they would otherwise. The United Nations independent expert on children deprived of liberty, Manfred Noack, puts it best. He says that deprivation of liberty means deprivation of rights, agency, visibility, opportunities, and love. Depriving children of their liberty is depriving them of their childhood. And as you can imagine, all of the effects that flow from that. So taken together, such evidence suggests that current criminal justice approaches are actually counterintuitive to both the rehabilitation of children and the safety of the broader community, which is what they're said to serve. And then it's not, of course, just the rights of children that are unreasonably limited. Various human rights committees have pointed to them limiting cultural rights of Aboriginal and Torres Strait Islanders, rights to equality and non-discrimination, and protections against torture and ill treatment. So then turning to the necessary service response, in theory, raising the minimum age of criminal responsibility could be quite a simple legal change. It would just be changing 10 to 12 in the criminal code. But mere legal change can't alone suffice. The human rights compatibility of this reform requires there to be an adequate and effective service response, something different to the criminal justice system that addresses both the therapeutic needs of children and young people, and as well as the safety of the community. It needs to balance those dimensions. And one of the great risks of not having a adequate and effective service response is that children and young people might be diverted instead into existing frameworks like the care and protection system or the mental health system, or that their behaviours might impact on others in the education system. none of which are sort of the least restrictive option in the circumstances. Raising the age, as I've said, needs to be supported by an adequate and effective service response. And put simply, it needs to address the root causes of offending by children. That is the long-term investment in the safety of the community. And even when above the minimum age, the rights of children favour measures that divert children away from the criminal justice system. So, for instance, through restorative justice processes. In this way, not only does raising the age of criminal responsibility support a range of human rights, but it also provides the opportunity to reconfigure how our existing systems address the needs of children and young people who are above the minimum age of criminal responsibility. It can be a holistic approach that doesn't just sort of arbitrarily focus on children below the age and not those above. Human rights principles have in this way helped to guide and design the implementation of the service response that we require to implement such a complex reform. What the Committee on the Rights of the Child recommends is that it focuses on a strategy of prevention, that it's a whole of system response, one that enables intervention at the earliest sign of a child engaging in harmful behaviours. So, for instance, where a child stops attending school, which is a huge risk factor, or where they show low-level signs of violence. At this point, supports and responses should be multidisciplinary, they should be prompt, they should be child-friendly, they should engage the views of the child and young person, as well as their family, their peers, and their community. Any response should reflect a long-term investment in the well-being of children and their families, and that is sort of as a key message of our Children and Young People Commissioner at the Commission, the best way to ensure the sustainable safety of our communities. Now, as I said earlier, the ACT government's published a position paper on how they're giving some hints of how they propose to raise the age. Whoops.
Sorry.
That's okay. And some of the elements that they've been flagging for the service system is intensive family-based therapies and conferencing, the creation of a multidisciplinary panel that gets involved early on at first signs and assesses the complex needs of children and young people. And then, of course, in exceptional cases, a jurisdiction for the court to require that a child or young person remains at a certain place temporarily to engage with necessary supports, so intensive therapy. So that sort of gets into the question of how do we ensure community protection, which is, and I must stress, there are diverse views in the ACT community about raising the age. It's not unanimously supported, because for many in the community, the idea that younger children might not be held accountable for serious offending is concerning, and understandably so. If we're unable to detain children who commit serious offences, from their perspective, how can we ensure accountability and keep the community safe? Now, the safety of the community is an important element from a human rights perspective. It's a legitimate objective that needs to be appropriately balanced with the rehabilitation of children and young people and their development. The government's position paper, however, indicates that legislation will be drafted in a way that leaves open the option of accepting certain serious offences committed by 12 or 13-year-olds. Now, this wouldn't be novel. This wouldn't be the first time that this has occurred. Current law in New Zealand, for example, allows children who are aged 10 to 13 to be charged with serious offences like murder and manslaughter. But they can only be convicted if the prosecution can prove that they knew that their acts were wrong or otherwise unlawful. Now, in theory, this might seem like a perfect way of sort of striking the balance between children's rights and safety of the community, that those capable of forming criminal intent are identified, they're held accountable, and they're sentenced to detention. However, this is the way the system already works here in Australia in relation to those aged 10 to 12. And what we've seen is that this presumption, or rebutting this presumption, is complex, it's costly, it's legally confusing. We have a case in the ACT that had to be appealed just because the principle wasn't understood. But worst of all, keeping a child on remand while lawyers and psychologists work out whether or not they knew what they were doing was wrong, already has those sort of criminalising and harmful effects. They are already kept in detention. So the harm is already done. Having exceptions then, like accepting particular offences and retaining a criminal justice approach, is controversial from a human rights perspective. It's premised on the assumption, which is not supported by evidence and is irreconcilable with the rationale for raising the age, that children can form criminal intent for some offences and not others, that we instinctively would know that murder and manslaughter are wrong, and sexual offences too, but we can't form that capacity for lower level offences like burglary and arson and other things like that. Raising the age with exceptions for offences unfortunately arbitrarily delineates the protection enjoyed by some children without any, and it has no rational prospect of achieving a deterrent effect, because if children can't distinguish right or wrong for any offence, it's not going to have a deterrent effect for the serious ones. So unsurprisingly then, the ACT Human Rights Commission is staunchly opposed to the ACT raising the age with exceptions, and the Committee on the Rights of the Child has been very vocal on this point too. It indicates that exceptions do not reflect a rational understanding of the development of children, and generally speaking, their only function is to respond to public pressure. There are also arguably less restrictive ways to ensure the accountability of children, young people, and community safety through this alternative service pathway that I've sort of discussed. Diversions, referrals to restorative justice processes, and as a last resort, that sort of short-term confinement for intensive therapy are all ways to ensure that the accountability of a child. People who have experienced harm can potentially provide victim impact statements that are considered through this alternative support system, so that a child or young person can, if it's appropriate, understand the impact of what they've caused. So sort of getting to the end and moving to the next slide, I haven't really spoken yet about what role lawyers play. I've sort of tacked this on at the end. But just to give you, and I can address this if we have time for questions, but one of the key features of the Human Rights Act and the ACT is that when it comes to law reform, is that all new bills introduced by a government minister must be accompanied by a statement of human rights compatibility. And this is signed by the Attorney General. Importantly, the Human Rights Act doesn't require that the government introduces laws that are human rights compatible. And courts can't invalidate our laws if they are found to be incompatible with human rights. So it's therefore open to the government to introduce laws that are human rights incompatible. We wouldn't want to see this, of course, but it has that discretion. Despite this, and unlike Victoria, the ACT government has a laudable record of never having before introduced legislation with a statement of incompatibility. The ACT Human Rights Commission would probably be quite concerned if exceptions were introduced alongside a statement of incompatibility, but this is an issue that we'll see play out down the track if it does. So in this context, those with legal training play a really important role within the public service in that discourse. Legal policy officers, they prepare the briefings, the discussion papers, the consultation, they instruct about the sort of low-level choices on drafting of the bill and implement the minister's directions, his policy intent, his or her policy intent, in fact. Lawyers within the Justice Community Safety Directorate in a separate team support the Attorney General in his function of providing compatibility statements by reviewing the proposed bills for their consistency with human rights, and then they advise him about whether it's consistent or whether it's not. My colleagues and I within the ACT Human Rights Commission are an independent voice in this process. We look at cabinet submissions, and where we disagree with conclusions about human rights consistency, we comment. And where we all disagree and where it's a fairly fractious debate, specialist advice can be sought from the ACT government solicitor. So those are some of the ways in which human rights lawyers, there's a dialogue internally within the public service about the human rights consistency of various bills. I'm conscious of the time, so I'll leave it there. But
thanks so much, Kevin. And look, there's been one question from one of our students going by Priako, I think. Is the offending in company with older children and adults, or is the offending in company sort of issue, the peer pressure issue with same age children? Which just gets me thinking about, I think, one recommendation the Commission has made about focus on offence definition where there has been encouragement or incitement by older children or by adults, and that's how young people get involved in offending. Maybe that's the way to respond to the question that we have in the chat.
Potentially, I think what I'd say is just in that Victorian instance, the 13-year-old was in company with an older brother, 18-year-old. So it really does sort of make that point about how powerful peer influence is in terms of leading people down paths of behaviours that are considered harmful. In terms of incitement, while we did make a recommendation to clarify that, from my perspective, because criminal responsibility is separate to the existence of an offence, I would say that offences of incitement already do apply and would apply, but it's important that that be clarified and sort of any myths be dispelled in the context of this reform.
Thank you so much. Wonderful to have your perspective on how you went from a law student to your current role. And we'll swap now to hear perspectives from Minister Shane Rattenbury, MLA from the ACT, who is the ACT Attorney General, to speak in more detail about the government's position paper and the law reform process that got lawyers engaged in shaping that issue up to the point that we have now. So I'm going to stop and restart the recording as I have been doing.